Getting some Scotus opinions here in just a bit. Tonight, let me just adjust. Sorry, I'm working on dual platforms right now. So give me 2 seconds to just put this up. Anyway, we are going to be getting some Scotus opinions here in a few minutes. We're excited for it. I do have some house construction going on today, so normally I will do oral arguments live. However, oral arguments will be tonight at 9:30 after my children are in bed. I am live on YouTube, Twitch, and TikTok right now, so I apologize, but I'm using 2 devices, and I had to put a filter on because I have hag face this morning, so apologies for that. But anyway, we'll be getting opinions, but tonight, the case we are going to do is probably one of my favorite cases they're going to take this session. It is a 2A case, Wolford v. Lopez. The questions tonight are going to be whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may preemptively prohibit the carry of guns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier, and whether the Ninth Circuit erred in solely relying on post-Reconstruction era and later laws in applying Bruin's text history and tradition test in direct conflict with the holdings of the 3rd, 5th, 8th, and 11th Circuits. If you do not know anything about the Ninth Circuit, they are a notoriously, for lack of a better term, liberal bunch. It doesn't mean all of the rulings out of the Ninth Circuit are. They are just tend to be a more liberal and or activist court. But we should be getting decisions in about 10 minutes or so. They're going to drop. Unfortunately, sometimes we have to wait if they get rather long-winded. I will go through some of the possible decisions we may be looking at. Let's see. Okay, we could be looking at Villarreal v. Texas, which is a case that we covered at the beginning. It was the very first case in this session. This is a case about the gentleman who had a murder conviction and was saying he was deprived of his Sixth Amendment right to counsel because he was testifying in his own defense, and when they went into recess, he was still giving testimony, and the judge specifically said, look, you can talk to your lawyer, but you can't talk to your lawyer about your testimony. It's one of those, maybe, maybe not. I don't know what's going to happen with that, but I am very interested in the case because it's a case I followed since it left Texas. Choy v. Salazar, this is the case where the therapist in Colorado said that Colorado's rule essentially requiring her to perform the medically standard practices of affirming somebody's gender goes against her religious liberties and her First Amendment rights. We already got Boss v. Board of Elections. Let's see what else. We already got Boe. We could be looking at Louisiana v. Calais, which is the reconsolidated case about racial gerrymandering in districts. However, I'm feeling like that's going to be a a June decision. Could very much be wrong. We already got Case v. Montana. Let's see what else we got. Let's check the look at November. We could be looking at the Rico v. United States, which was about the fugitive tolling doctrine in regard to people who are released and then, flee and da-da-da. Let's see. We could be getting the tariff decision today. We just don't know. Feeling like tariff may be more of a March issue. I've been wrong before, though. I have been wrong before. And thank you, everybody, coming in, liking, following. I love you all so much. You are just absolutely amazing people, and I love having you here. Let's see. What else? Potentially something from December. We could be looking at Cox v. Sony. We could be looking at Aurelia Orellana v. Bondi. Cox is the internet case. The Bondi case is about asylum seekers and de novo review. First Choice Women Resource v. Platkin. We did that one, which is about the chilling of the, First, it's about whether the federal court can step in and the chilling of First Amendment rights. It's the interesting case about the Women's Resource Center, aka the Abortion Prevention Clinic. And then we got Olivier versus City v. Brandon. I don't think any of those December cases will be popping today. But again, been wrong before, maybe wrong now. You never know. Does anybody have questions or anything right now? Because I can answer those real quick while we're going. But tonight, we're going to be doing Wolford v. Lopez. My construction people usually start about 9:30 for me. So I'll cover these in the morning. Nationwide protests today. Everyone walk. Oh, yeah, we're not doing that in here. We're just, this is Scotus particularly. I just want to watch him lose the tariff decision and spin out. Thanks for covering. Not enough people pay attention. Thank you, Justin. We shall see. I don't know that we'll get the tariff decision today. It feels like a March drop, but dang it, I've been wrong before and I will be wrong again. That is just how it works. Sorry, I'm working between two platforms, so forgive me because I know it's kind of hard with the back and forth, but I am trying to keep up with people. If you're coming in, like, follow, share, do subscribe, do all the shits. I don't know. There's, a million different things, and I don't work with YouTube much, but that's that's what I'm going to try to start doing. So I apologize if this is not what y'all are used to. Let's see. Let's head up back to opinions of the court. So the tariff decision, I'll talk a little bit about that one. We all watch the tariffs together here on TikTok. The tariff decision was notoriously difficult to read the justices on. I feel like even like, and they're my Bible is Scotus blog, right? Even Scotus blog agreed with me. They're like, we don't know where they're going to go with this. And we really, really, really don't. Justin on YouTube, I feel like they're going to keep dangling the tariff decision for a while because why not? Well, it's possible. Now, the tariff decision was like an expedited case. However, they don't have to who's going to make them, right? Who's going to make Scotus and tell Scotus you have to do this? But they generally tend to be fairly responsible about how they put these decisions out. Oh, another one I didn't mention, Trump v. Slaughter. We could be looking at Trump v. Slaughter, which would, I think, would very much affect our case for tomorrow, which is going to be Trump v. Cook, a very similar case in the same vein of Trump v. Slaughter. So this is going to be a fun one, guys. This session is going to be lit. We are going to be doing a 2A case tonight. Wolford v. Lopez is the case I'm going to cover tonight. I'm going to cover it in what I call night court. I got construction going on in my house. They start at 9:30 and it's really fracking loud. And my studio is right next to where they're doing it. And I love y'all. And I don't know if any of y'all are parents and can feel this, but I am not getting in my boys' rooms to do a cast because no, not doing it. So we will do that tonight after they are in bed because they got to go to school. Let's see, what time is it? 8:56. Okay, so around 9 o'clock, the judges will be reading decisions. I love me some Sotomayor, but that heifer can get real long-winded. So depending on how long it takes them to read the decisions may depend on how long we're waiting. But I will refresh like a madman starting at 9 to see how quickly we can get whatever they are going to drop. Let me open Scotus blog real quick. They are usually there, so they have a live chat going. where I can see what they may be dropping. Yes, per curiam, it's view of each term. Let's see. Let me see. Did we get something already? But usually they can at least tell me how many we're expecting. We get a number of boxes, so it's helpful. But anyway, so we are just waiting right now. If you have questions, please drop them in the chat. So tariff decisions, I'm curious, anybody on the tariff decision, since we're just kind of in that vein right now and waiting, Lady Google and I, my lovely mod and lovely co-host on Politically Deconstructing, had discussed this. Do y'all think that they should say going forward, like, and ending the tariffs, but like the money that's already lost is lost, right? Because let's be so real, the logistics of just refunding all that money would be insane. Or do you think that they should say we got to refund it all because that could cause some havoc to our system? I would say that, like, on a soul level, I think it should be this sort of like everything should be refunded. But on just a keeping it very organized level, I would think it should be going forward. Does that make sense? We don't have anything yet. They won't drop anything until a bare minimum of 9 a.m. And we got to wait for them long-winded turds to read out the decision. It drives me crazy. But I am curious what people think. And if you are on YouTube or Twitch, just drop a comment in the chat. I am so excited everybody is here. I love you guys. And don't forget, night court tonight at 9:30. And if you're not able to be here, for my TikTok people, just follow my YouTube and you'll be able to catch all of it over there. It's in my link tree, but it's also very easy. It's cast as courts. So Justin says on YouTube, I don't think the logistics are as bad as folks think. They keep track of every penny, and he should have to give it all back. We won't see it, though, and that sucks. Justin, I can kind of moderately agree with you. I think I'm more concerned about, like, perhaps at this stage, the system is already so chaotic that I don't want to inject more chaos into it. But I feel where you're coming from, Justin, and I am not going to say that you're wrong. Let's see. Trump will not fall in order. This is something somebody on TikTok says. It says, Trump will not fall in order. He will claim he defied them while issuing small. I know. Justin on YouTube says, if they strike down his blanket tariffs, I'm thinking that means the tariffs on the EU for the Greenland thing are gone too, right? Justin, that's a great question. I'm thinking if they move that, basically Congress has to say he can do this, it's really going to be dependent on Congress. And since right now we have a lot of Republicans in Congress, maybe not. I think he's already got them ready to move on, like, whatever he wants to do. Okay, let's start refreshing. It's 9 a.m. Woo! Let's check what Scotus blog says. We got anything yet? Let's see. Nope, we don't have anything on them yet. I'm going to start refreshing like a madman. He can still do small tariffs for short times. I think we're going to get a lot more about what he can and can't do should we get a tariff decision today. It would make sense, but potentially, maybe not. It just depends right now. I'm honestly, I won't say, don't get me lying this early. That's all I'm going to say. So I am really hoping that we get Villarreal v. Texas. Now, the tariff decision, I don't think we're going to get it today. I hope we're going to get it today. I don't think we're going to get it today. You know the one I want, though? I want Villarreal v. Texas because that was the first case that was argued. It's the case I followed since Texas, and I want it. I want to know how much right to an attorney does the defendant have? Because I think logically, barring them, we got Berk v. Choy. Let's see, I don't think we covered Berk v. Choy. Yeah, this one's boring. Nobody cares, but I'll read you the holding. So Delaware law provides that a plaintiff may not sue for medical malpractice unless a medical professional attests to the suit's merit in affidavit of merit and that accompanies the plaintiff's complaint. Delaware Code Title 18, petitioner Harold Berk sued Dr. Wilson Choy and BB Medical Center in federal court for medical malpractice under Delaware law, but failed to provide the affidavit required by 6853. Berk argued that 6853 is not enforceable in federal court because it is displaced by the federal rules of civil procedure. The district court dismissed Berk's lawsuit for failure to comply with the Delaware affidavit law, and the Third Circuit affirmed. Delaware's affidavit law does not apply in federal court. When a plaintiff brings a state law claim in federal court, the court faces a choice of law problem, whether to apply state or federal law. Rules of Decision Act directs federal courts to apply state substantive law unless the Constitution or treaty or statute otherwise requires or provides. The Rules Enabling Act, which authorizes the Supreme Court to adopt uniform rules of procedure for district court, provides the rule of application in federal law. So when the federal rule of civil procedure is on point, it displaces contrary state law, even if the state law would qualify as substantive. The analysis is straightforward. The court asks whether the federal rule answers the disputed question. If a federal rule does, it governs unless it exceeds statutory authorization or Congress's rulemaking power. So essentially, they're just saying, yeah, he can do it because he doesn't need it because federal law says he doesn't need it. Okay, let's see. We're getting anything else? This is not the last decision of the day. The decision was delivered by Amy Coney Barrett. So this is not the last one. We'll see what else we're going to get. Haven't gotten anything yet, but we will have more than one decision. Let's see. See if we get anything else. Sorry, I'm checking Scotus blog as well. So I am trying to figure out what all we're going to get today. Sometimes they update. The only one right now is Berk v. Choy. It's basically federal rules of procedure issue. Berk sued in federal court, and he didn't provide a certain affidavit that Delaware requires, but federal rules of civil procedure supersedes that. So Berk is good, and he didn't need it, and that's all the court basically said. I know. I really kind of just try to make these easy. I don't give a fuck about Berk v. Choy. I'm going to be so real. Okay, we got Ellingburg v. United States. This is Kagan. This is not the last decision of the day. The Mandatory Victims Restitution Act of 1996 requires defendants convicted of certain federal crimes to pay monetary restitution to victims. Although petitioner Ellingburg committed his crime before the MVRA's enactment, he was sentenced under the MRVA in order to pay about $7,000 in restitution. Ellingburg raised an ex post facto clause challenge in his continued restitution obligation. Eighth Circuit concluded that the restitution under the MVRA is not criminal punishment subject to the ex post facto clause. So they held that restitution under the MVRA is plainly criminal punishment for purposes of the ex post facto clause. Whether a law violates the ex post facto clause requires evaluating whether the law imposes a criminal or penal sanction as opposed to civil remedy. That question is one of statutory construction that requires the court to consider the statute's text and structure. When viewed as a whole, the MVRA makes abundantly clear that the restitution is criminal punishment. The MVRA labels the restitution as a penalty for a criminal offense. Only a criminal defendant convicted of a qualifying crime may be ordered to pay restitution. Restitution is imposed as sentencing for that offense, together with other criminal punishments. Sorry, I lost my place, such as imprisonment and fines. At the sentencing proceeding where the restitution is imposed, the government, not the victim, is the party adverse to the defendant. Further, the federal MVRA restitution regime is codified in Title 8, Crimes and Criminal Procedures, and the statutory provisions authorizing the restitution orders are contained. A district court imposing the restitution must follow the procedures applicable to other criminal penalties. So basically, he filed ex post facto saying, hey, bro, like, this wasn't even up when I did this, and now you're saying I had to pay this. And then they were like, but it's not a criminal punishment, it's just like restitution. And he was like, nah, bro, it is restitution. And the Supreme Court said, yeah, bitch, that is a criminal penalty. So that is the quick and very low-key synopsis of that case. Okay, yeah, we didn't get tariffs today. This is the last one we got, which is Coney Island v. Burton. We did not cover any of these cases, guys, but I'm still here loving and reading you all the decisions. This Coney Island one is another federal rules of civil procedure bullshits. And nobody cares. Like, I'm sorry, nobody fucking cares about this. Like, I'm not even gonna read you this decision. You may go and read it yourself because no one fucking cares. I'm with Ari on this 1,000%. None of these, the tariffs decisions are just, they're not coming until March. They're not going to be here until March, but it will still be here reading all the decisions. I'm not even reading the Coney Island thing because, frankly, I'm going to bore y'all to tears. Now, my construction is going to start in about 20 minutes. So, again, I will not be doing my case today, which is my banger case. I love 2A cases. That's my shit. However, I will not be doing my case today. I will have to do it tonight in night court. I will be on YouTube. I will be on here. And even better for y'all, I can pause so you don't see me just yelling at them like, what the fuck are you doing? But it's Wolfer v. Lopez at 9:30 p.m. tonight. It's a very fun case about Ninth Circuit errors in making sure, like, are they even following the text of Bruin when they're making these decisions? And also, did they err in saying that people just can't carry on private property unless the owner gives express? It's a whole thing. It's going to be a very interesting case. It's not the best 2A case we have this session, but it is a good one. So we're going to see that. I will be live tonight in night court, 9:30 p.m. Central Standard Time. Otherwise, I love you all so much. And I will see y'all later. Actually, you know what? Does anybody have any questions real quick? If you have a question, please just drop it in the chat real quick. And I will take care of it before we come back tonight. I'll give y'all a couple minutes just to write it out. Oh, you're so welcome. Scotus Blog does a better job with decisions than me. But listen, I'm just here explaining shit to y'all in a way it makes sense. Yeah, if anybody's got a quick question, just please drop it in the chat. I got about 1 more minute and then I'll go ahead and get off. So I'm not really seeing anything. But again, yes, I love you all so much for being here. Come to night court tonight. And if not, follow my YouTube because my YouTube will have all my recordings as well. So you will be able to see it later if you want to take a look at it. I do not cover every single oral argument because sometimes just nobody cares. Like the Coney Island case. Nobody fucking cares. Unless that's specific to you, you don't give a fuck about it. I cover cases that matter to everybody. That's why it's cases to care about. Okay, I'm not seeing any questions. So what I'll do is I'm going to go ahead and get off of here. Come back tonight for night court. I will be here. And if you cannot come back tonight for night court, please just follow my YouTube. It's in my link tree. It's Cast as Quartz, and you can see it all over there. All right. I love everyone. Thank you so much for being here, and I will see you all soon. Bye, guys.